Hello everyone, again welcome. My name is Ksenia Kirichenko and I'm a program coordinator at ILGA-World. We are based in Geneva and this is a webinar about strategic litigation on LGBTI cases before treaty bodies. This webinar is a part of our series of online advocacy webinars and roundtables, which ILGA is organizing because of the COVID crisis to make sure that our communities and activists from our movement are still connected and we have platforms to discuss different issues and share knowledges. We have 4 experts here and also myself. Sebastian, who is our intern with ILGA, will be helping with technical details. So for experts, we have Dmitry Bartenev from Russia, who is an attorney and who specifically works with coming out LGBT groups and led a lot of groundbreaking cases before European Court of Human Rights, but also treaty bodies. We also have Arpi from ILGA-Europe. Arpi is a senior litigation officer, right? And Arpi has experience with supporting different strategic litigation opportunities in Europe and also experience with third-party interventions on LGBTI cases before treaty bodies. We have Rosanna from Sri Lanka, Executive Director of Equal Ground. Rosanna can share with you information about a unique case about criminalization of female same-sex relations in Sri Lanka. And this is the case which was recently brought to the Committee on the Elimination of Discrimination Against Women. And we also have Tess from ICHR, who can also share with us information about third-party intervention and experience of ICHR on strategic litigation on LGBTI cases and also cases of human rights defenders. So we will have 5 presentations during this webinar, and after that we will have a Q&A session. So you can send your questions to our guests, our experts, using the Q&A feature. So I hope everyone can see the Q&A chat box. And if you will have any questions during the webinar, please feel free to share it, to send these questions. And you can do it at any point, but we will address these questions after presentations. You can send your questions with your name, but also anonymously. If it's important for you, also take this into account. Also, like generally, we expect everyone to be respectful even in the questions, and I'm sure you would agree with this rule. So this is that's it for the organizational introductory part. The last thing maybe is that we also have a survey. A quick survey, maybe you will need 2 or 3 minutes to fill it in. And when you will leave the webinar, you will have automatically a page with the survey. So we will really appreciate if you could provide us your feedback. Let's start with the substantial part. And we will start from getting to know you more. And we have 2 polls for you. So Sebastian, could you please help me with this? We have 2 questions to you and we will ask you to answer this question. So our first poll is about your experience with litigation on LGBTI cases, either on national level or regional or international. So do you have any experience with litigating LGBTI cases? Please answer this question. Yes, no, or not sure, maybe. Okay, so we have half of the participants, half of the attendees who actually have experience with litigation on LGBTI cases, and I hope that this webinar will provide you more information about international opportunity. But half of the participants who didn't have any experience, I think that maybe this webinar could encourage you to consider this topic, this method of work, and thank you for joining. Then we have a second question. What is your knowledge on treaty bodies litigation on LGBTI cases? So this is exactly the topic of our webinar. And what is your background on this? What is your knowledge on treaty bodies litigation on LGBTI cases? Maybe you don't know anything and came here to get some information. Maybe you know something, or maybe you want to know more, or maybe you're already an expert. So please put your answer. Okay, let's see what are the results. That's great that almost half of the participants know already something about litigation on LGBTI cases before treaty bodies. I hope you will get more information on this during this webinar. And for those of you who do not know anything, I also hope that we will provide you some insights. So thank you for this. And now we will start with presentation. And for this, I need to share my screen. So this week, not this week, recently, ILGA-World launched our Russian version of strategic litigation policy paper. And this is one of the reasons actually why we decided to organize this webinar. So I hope you can see my presentation. So yeah, and I'm going to tell you about our toolkit and also to share with you some information about litigation on LGBTI cases before treaty bodies. So just to make sure that everyone is on the same page, I would start from introducing you to treaty bodies. I know that many of you already know what are treaty bodies, but just in case. So treaty bodies, they are human rights mechanisms within the United Nations systems. And as you can see from the name, treaty bodies, they are related to specific treaties. So there are 9 main human rights treaties or conventions at the UN system, and each of the conventions has its own committee. So committees or treaty bodies is the same. They are committees of independent experts, and their function is to monitor implementation of specific treaties. For example, the International Covenant on Civil and Political Rights by state parties. There are 10 different committees. Some of them are of a more general nature. For instance, the Human Rights Committee, which is about the International Covenant on Civil and Political Rights. Some of the committees have a focus on specific populations. For example, the Committee on the Elimination of Discrimination Against Women, or the Committee on the Rights of the Child. And some of them are focused on specific topics, such as torture, the Committee Against Torture, or, for instance, racial discrimination, the Committee on the Elimination of Racial Discrimination. And there are 9 of these committees. In their work, all the committees, or most of the committees, use 3 main methods, which are country periodic reviews. So when your country ratifies a treaty, every 4, 5, 6 years, the country has to provide periodic reports about implementation of these treaties. within the country. It's a country review process, periodic country review process. There are also general recommendations or basically authoritative explanations of the provisions of conventions by committees. And last but not least, and this is our topic of the webinar, it's individual complaints. So basically litigation before treaty bodies. Most of the treaty bodies, they can act in a very simplistic way. They can act as like a supranational courts, and they can review specific cases after authors exhaust all the domestic remedies. So treaty bodies individual complaints, what is it and what are the specificity of these mechanisms? So first of all, in order to use strategic litigation before treaty bodies, your country has to ratify an optional protocol. So for example, the Human Rights Committee is monitoring the International Covenant on Civil and Political Rights. However, if your country ratified the ICCPR, it doesn't mean that by default you can bring individual cases to the Human Rights Committee. For doing this, your country also has to ratify so-called optional protocol. So the protocol establishing procedure for individual communications. Then treaty bodies individual complaints, it's a consideration of a specific case, which means it's a specific person or persons in a specific circumstance, something specific happened, and you think that this is a violation of concrete provisions of human rights international treaty. So this is a specific case. It's not a discussion or analysis of a situation in general. As a result of case review, treaty bodies provides usually individual and general recommendations to the state party. So let's imagine that you have a case about, for instance, detention of trans women in a country X. And this case was brought to, for example, the Human Rights Committee. If Human Rights Committee found violations of convention of the ICCPR covenant, then it can recommend the state party to provide individual remedies to people who suffered. So for example, to release people who were illegally detained. But also it can provide more general recommendations, for example, to provide trainings to police officers to make sure that they do not illegally detain LGBTI persons in this country, or to change legislation, or maybe to organize some public awareness raising events, etc., etc. Then there are two important principles which you need to take into account when going to treaty bodies with individual complaints. One principle is subsidiarity, which means that you can go to treaty bodies with your case only after you exhausted domestic remedies. And usually it means that you have to go through national courts before going to treaty bodies. And then there is a principle of the uniqueness, which means that for one case, specific case, you can choose and you can use only one international mechanism. So normally you cannot bring the same case to, for example, Inter-American Court of Human Rights and the Committee on the Rights of the Child, for example, treaty bodies. And you can also choose between treaty bodies, because you know that there are 9 treaty bodies. Most of them have treaty bodies individual complaint mechanisms, but you have to choose to what committee you are going to bring your case. There is a possibility of third-party interventions for cases brought to treaty bodies, and we have Tess and Arpi who will be talking more about it. And also most of the treaty bodies, they have a procedure for follow-up. So after the decision has been made, the state party, if there was a violation, of course, the state party has to periodically inform treaty bodies about what has been done to implement this decision. And also civil society groups can also participate usually in this process and provide their alternative information about the situation with a specific case, and also implementation or non-implementation of general recommendations. So this is a scheme of our treaty body strategic litigation toolkit. So we know that For instance, the European Court of Human Rights has been widely used by LGBTI defenders on different topics, and we have already developed jurisprudence from the European Court of Human Rights. However, treaty bodies mechanisms, they are not as popular among LGBTI defenders. And at the same time, there is no, for example, comprehensive user-friendly database, which would allow you just to go there and to type LGBT and then to receive the list of all the cases reviewed by treaty bodies. So to fill in this gap, we decided to create this toolkit. And last year we published it in English and in Spanish. This year we also translated it into French and Russian. And you can find this toolkit on our website. And Sebastian can share with you some web links on chat, so you can go and see it actually. The toolkit consists of several parts. One, maybe the most interesting one, is a policy paper. It's a document about what is strategic litigation in general, what are the procedures in treaty bodies. There is also a chapter with the analysis of treaty bodies jurisprudence, reviewed cases and also pending cases. It has also regional sections, 6 regional sections with quotes from experts, activists, litigators, lawyers from 6 different regions, and also information about case law of treaty bodies related to this specific region, and information about ratification of individual complaints mechanism from different countries in different regions. So if you want to know if you can bring cases on LGBTI from your country, you can check the policy paper and to find your country and to see what are the available opportunities for you. And last but not least, there is also a section on useful resources and useful contacts. So this is a policy paper. We have it now in 4 languages. Then we also have 2 case digests. Regional mechanisms, Inter-American Court of Human Rights and European Court of Human Rights. And most, I think more interesting is a case digest on treaty bodies. So it's a document, only in English, unfortunately, but still. It's a document with information about 6 thematic groups of cases on LGBTI reviewed by all treaty bodies. And we collected from different sources information about these cases, facts of the cases, decisions, reasoning of treaty bodies of the committees, remedies provided on these cases, also comments like what is the importance of each particular case, and information about follow-up, so what has been done by different countries after the decisions has been delivered by treaty bodies. Then we also have a table, periodically updated table of treaty bodies jurisprudence on our website to make sure that we have up-to-date information. And finally, we have regional booklets. We prepared it for Europe and Central Asia and for Latin American and Caribbean. So you can also find booklets on our website. So here you can see title pages, first pages of our strategic litigation policy paper in English, Spanish, French, and Russian. You can find it on our website. And we also have, these are pages from regional sections of our policy paper. So here you can see, for example, Asia, Africa, and this is an example of our regional booklet on LAC region. We have some other polls for you. And before we start to go here, I would just ask Sebastian to share the next poll. This is a question for you. There were more than 1,500 decisions made by UN treaty bodies in total on different topics. How many of them concerned LGBT? What do you think? Overall, there were more than 1,500 of decisions on different topics. And how many of them were about LGBTI? Or actually LGBT? Okay, let's see the results. Most of the people think that there were 31. And let's see what is the answer. So the right answer is 31 decision, exactly. So there were 31 decisions on LGBT or sexual orientation and gender identity made by treaty bodies so far. These decisions were made only by 3 committees: Human Rights Committee with the highest number of decisions, then the Committee Against Torture, and the Committee on the Elimination of Discrimination Against Women. So we have the second poll. It's about countries. Most of treaty bodies' decision on LGBT were made against which country? And Uganda, Australia, Russia, or Colombia? What do you think? Which country received the highest number of decisions on LGBT from United Nations Committee? Uganda, Australia, Russia, or Colombia? Okay, let's see the results. Most of the people think that is Russia. Then also we have 11 people who think it's either Uganda or Australia. And for Colombia, there were only 3 people who voted for this. Let's see what is the right answer. So actually there were 2 right answers, which were Australia and Russia. And it's also interesting that the third country which received the highest number of decisions was Sweden. And later you will see why. But the highest number, 5 decisions, were received by Australia, Russia, and Sweden. Colombia received 1 decision, and it was decision about family rights. And Uganda did not receive any decisions. There were no cases against Uganda. In general, you can see that there is a regional imbalance. For example, for Oceania, there were only 2 countries, Australia and New Zealand. For North America, it was only Canada. And actually, the United States did not ratify any optional protocols. For LAC region, we have only Colombia, and it was only 1 case. And then the most of the cases are from either Europe or Central Asia. And we didn't have any cases from Africa, and we didn't have any cases from Asia apart from Central Asia. And we have the third poll for you, which is about topics of decisions. On what LGBT or SOGI topic UN treaty bodies made the highest number of decisions? Criminalization of same-sex relations, hate crimes, asylum seekers, discrimination in employment and healthcare, same-sex families, or legal gender recognition. What was the topic most popular in the treaty bodies' jurisprudence on LGBTI cases? Okay, let's see the results. 30% of participants think that it's criminalization of same-sex relations. And actually the first case from treaty bodies, the first case won before treaty bodies, was a case about criminalization of same-sex relations, Tunin versus Australia. However, the right answer is asylum seekers. So far there were only 6 topics, and you can see that actually there were no cases on intersex, and no reviewed cases, no pending cases. There were only cases on LGBT, and the most popular topic was asylum seekers. So when LGBT persons came to usually North America or Europe, they asked for asylum, they were refused, and then they challenged this decision on the national level and then went to treaty bodies. Not all of these cases were won. I would say it was more or less half of the cases which were won, but you can see all the analysis of jurisprudence and specific arguments in our toolkit. So the second popular topic was freedom of expression, assembly, and association. Usually it was about any restrictions on gay rights or anti-propaganda legislation. 4 cases were made on both violence and violence, including hate crimes and hate speech, and recognition of same-sex families. 2 cases were on criminalization, and only 1 case, recent case, was about legal gender recognition. But you can find more information in our toolkit, and we also will hear from our experts about some of these cases on a later stage. And lastly, so I just want to share with you some results of the analysis we made. We analyzed all the decisions of treaty bodies on LGBT cases, and we identified gaps and opportunities for the future development. So first of all, as you know, there were only 3 committees who reviewed LGBT cases so far, which is the Human Rights Committee, Committee Against Torture, and CEDAW. At the same time, for example, the Committee on Economic, Social, and Cultural Rights, or the Committee on the Rights of the Child, could also be very interesting opportunities for LGBT cases. Then regarding specific topics on criminalization, so far there were only decisions on criminalization of same-sex relations between men. It was a case Tuning versus Australia. And we need we can think about also criminalization of lesbian relations or criminalization of certain forms of gender expression or sex work. Then on the topic of asylum seekers, more cases could be brought to treaty bodies on specific populations, such as LGBT women or intersex persons or children. And also there were no cases related to, for example, mistreatment of LGBTI persons who are seeking for asylum in, for example, camps, or refugee camps, or in the process of assessment of their asylum applications. On violence, there was only 1 case on hate crimes, only one case on hate crimes, no cases, 1 on hate speech. More cases could be brought on specific populations within LGBTI umbrella, or also on specific topics such as domestic violence, or so-called corrective rape, or conversion therapies, or medical interventions towards intersex persons. Then on freedom of expression, freedom of assembly, interestingly enough, there were no cases on restrictions or violations during NGO registration process for LGBTI activists or on funding, and more cases could be brought on dissemination of information, broadcasting, internet, etc. On family, there are a lot of gaps because there were no cases on children. So, for example, adoption, access to filiation procedures, cases related to custody, for example, disputes, and there were also no cases related to assisted reproduction. There were 2 cases related to marriage, but the first case was against New Zealand, and it was about access to same-sex marriage in generally. It was lost. This case was lost, so the Human Rights Committee decided that there was no violation, and therefore, but it was many years ago, quite a lot of time ago, and I think that right now the decision could be different already. On legal gender recognition, there was only 1 case, and it was a case against Australia, and the question was about marriage. No marriage requirement for change of trans person documentation. So no other requirements such as, for instance, surgeries or psychiatrist diagnosis or any other abusive requirements were challenged through jurisprudence of treaty bodies. There were no cases on discrimination in different spheres such as health, education, employment, and the Committee on Economic, Social, and Cultural Rights could be specifically interesting for these cases. There were no intersex cases, and as I tried to show you, there is, of course, there still is regional imbalance because most of the cases came from Europe or Central Asia, and no cases at all came from Africa or Asia and At the same time, countries from these regions, they did ratify conventions and optional protocols, so it can be an opportunity for you. So now I will finish my presentation at this point. Thank you for listening to it. The presentation will be sent to you on a later stage in our follow-up email. And our next speaker is Dmitry. So Dmitry Bartenev, who can share with you experience of organizing litigation, strategic litigation in Russia by a local group.
Yes, thank you very much, Ksenia, for the introduction, and hello, everyone. My name is Dmitry Bartenev. I am a lawyer, attorney at law, working in St. Petersburg, Russia. Let me just start my presentation. I hope you can see it. Okay, all right. Sorry about this technical delay. So have been working, have the privilege of working with St. Petersburg-based organization coming out for many years now, but also I practice human rights cases and various fields, not necessarily regarding LGBT rights, and I also teach international human rights and public international law at the St. Petersburg State University. I will briefly present their organization, the Coming Out organization, and I will then proceed with the overview of strategic litigation cases at the UN level, which the Coming Out has been working on. And I will conclude my brief intervention with my expert's view why the UN treaty bodies provide an interesting and fruitful opportunity for pursuing LGBT human rights. So the Coming Out LGBT group is a St. Petersburg-based organization, and while technically it's a regional organization, but it has been probably one of the most vocal LGBT human rights initiatives in Russia, despite all the challenges which we face in dealing with human rights of LGBT persons. And I'm convinced that the success of the organization of the LGBT group Coming Out is based on its approach to the strategic litigation. So the organization runs a diversity of programs where strategic litigation it serves not only as a tool for advancing legal protection of LGBT persons in Russia, but also strategic litigation is a tool for supporting the community, for reaching out to the community, for building the upon the broader support of LGBT persons and human rights experts and activists in general in Russia. And that's why the strategic litigation program is viewed by the community as something pertinent to their needs, as pursuing the good cause, the aspiration, meeting the needs and pursuing the aspiration of the LGBT community in general. And also that's why other human rights groups, including mainstream human rights NGOs, which do not necessarily work on LGBT human rights, they look at the experience and at the successes of the Coming Out as an example of successful integration, so to say, the litigation program into the broader agenda of the organization. The results, the outcomes of the strategic litigation program were summarized in a wonderful report. You can see the title at the slide at the moment. Also, there is a link available from the Coming Out webpage. The report was authored by Ksenia Kirichenko, who's opened this webinar today back in her years as a strategic litigation coordinator of Coming Out. I think it's a huge loss for the organization that Ksenia has moved to Geneva, but also, of course, it's a great acquisition for ILGA-Europe. An updated version of this report is also available from the Coming Out webpage. I invite you to look at it because it's not only a collection of legal cases. It's also a collection of personal stories. It presents the kind of interesting story of LGBT human rights advocacy, and it explains why certain cases are not necessarily important from the legal standpoint, but rather why they are important for explaining the human rights agenda of their organization, why they are meeting the needs of the human rights community, and why they are and how their success, so to say, their contribution to the advancement of human rights of LGBT person is assessed and measured. As many organizations in Russia, Coming Out has looked at the international opportunities, and we have a privilege of having access to the mechanism of the European Court of Human Rights. But at the same time, Coming Out has started to look at the other opportunities, including at the UN level. And at the moment, 5 cases has been brought to the UN Human Rights Committees, to the different mechanisms, 3 of them to the UN Human Rights Committee under the procedure of the ICCPR, and 2 other cases under the mechanism of the Committee on the Elimination of Discrimination Against Women. The cases brought to the Human Rights Committee, they deal with the issues summarized at this slide. So they are hate-motivated attacks against LGBT human rights activists and ban on the LGBT public assemblies. So the cases raise the issue of failure of the authorities to investigate violence against LGBT persons. Also the challenge the failure to acknowledge bias against LGBT persons as the motive for the ultimate motive for committing such crimes. With regard to the LGBT public assemblies, since recently most of the LGBT public assemblies in Russia, they are banned on the pretext of so-called gay propaganda. So the cases brought to the Human Rights Committee, they argued that failure to allow LGBT public assemblies on account of, so to say, homosexual propaganda, they violate freedom of expression, freedom of public assemblies, and that's why the legislative ban introduced by the gay propaganda laws is incompatible in general with the guarantees of the ICCPR. With regard to the CEDAW committee, the cases which have been brought to the CEDAW committee, they also relate to hate-motivated attacks against activists, but against women activists, and they raise more or less the same issues. But one of the cases deals with hate speech against LGBT, and it's a novel issue. It's a novel issue for the jurisprudence, for the case law of the UN human rights mechanisms, and I should say that's quite novel issue for international jurisprudence in general, including the European Court of Human Rights. With regard to the CEDAW efforts to pursue human rights using the mechanism of the CEDAW committee, recently the CEDAW issued its decision. It's successful, it's favorable to the applicant's decision in the case of two lesbian women from St. Petersburg. The case was brought by with the support of the Coming Out, and during the previous webinar it was explained in details by my fellow colleagues, so I will not spend much time on it, but it's a very important case because it's the first CEDAW case dealing with lesbian rights. I mean, the case which was decided on the basis of the procedure of individual complaints. Indeed, the CEDAW has issued several opinions and concluding observations following deliberation of the country reports, where it has already raised the issue of lesbian rights as women's rights. But it's the first case decided based on the procedure of individual communication. In its concluding observations, the CEDAW committee invited Russia. It recommended certain specific to the applicants and also systemic measures to be implemented by Russia. So not only the payment of the compensation and provision of support to the victims, but also the committee formulated several specific general recommendations for Russia, including provide gender-sensitive training for police and investigative authorities to avoid the failures which were criticized by the committee in this case, namely the failure to acknowledge that violence against the two women applicants was a hate crime, and it was motivated by the homophobic bias. And also the committee invited the Russian authorities to investigate promptly, thoroughly, and impartiality the allegations of gender-based violence motivated by hate against lesbians. This is a systemic failure of Russia, as the Coming Out has documented in its activities, because whereas many cases have been brought to the attention of the Russian authorities raising the issue of violence, homophobic violence against women, against lesbians, against gays, but still Russian authorities have not opened cases to acknowledge that this violence is something not compatible with human rights obligations. Let me briefly explain why litigating cases using the UN human rights mechanisms is an important opportunity, and I will explain my personal and expert's view in this regard. The question which might be asked by especially lawyers working with the international mechanism is what is the legal status of the decisions, of the views of the human rights mechanism? Why should we actually look at this opportunity, since the status in the domestic context, in the domestic legal framework is quite uncertain? I invite you to look at the successful story, not necessarily related with the LGBT human rights advocacy, but still quite pertinent. In the case of Svetlana Medvedeva versus Russia, which I also had a chance to litigate at the CEDAW level, the committee criticized Russia for the so-called ban on the for the so-called prohibited professions for women. As many other countries, Russia maintains a list of professions which are not accessible for women because of various grounds. It's not relevant for this webinar, but in the end, the committee adopted a decision which found several violations of the CEDAW Convention. We tried to implement these views of the committee, going back to the Russian courts, and surprisingly, the Russian Supreme Court acknowledged that the decision of the CEDAW committee has a legally binding obligation, has a legally binding effect, stemming from the international obligations of Russia to comply with the convention on the elimination of the discrimination against women. And it clearly advised and obliged Russian judicial system to take into consideration the views of the committee. And in the end, the Russian courts reversed previous judgments, previous negative judgments against the applicant, based on the findings of the CEDAW committee, and found the discrimination which the CEDAW committee acknowledged in its views. That's a successful story, not only for the applicant in that case, but I think it has a very important implications for advocating the legal status of the CEDAW committee judgments views, especially in those jurisdictions similar to Russia, where international law has its clear place under the constitution, and it has a priority over national legislation. And also if we look at the general measures, Russian government, following this decision and based on the advocacy efforts of women's organizations, decided to review the list of prohibited professions for women. And so in the end, it implemented not only the individual decision for the applicant, but also the decision, it implemented the recommendations of the CEDAW committee. So why the UN treaty bodies? Why we should look at the opportunities which they present? Well, Ksenia has already summarized the cases and has already explained that at the moment the UN human rights committees in general, they have decided over 30 cases related to LGBT human rights, which is quite a lot. And they have raised a number of important issues. But still, the jurisprudence of the committees, of the UN committees, I should say, it's quite limited. So we should still press on the committees to progressively develop its legal practice and to acknowledge that LGBT human rights advocacy and LGBT human rights, I mean, it's not only a European matter, so to say, but it's a universal matter. The European Court of Human Rights, as probably most of you are aware, has been quite vocal, quite active on tackling human rights violations of LGBT human rights persons. But at the same time, the European Court of Human Rights has been criticized for being too progressive, so to say, too active on LGBT human rights. If the UN treaty bodies if they follow so to say, the activism of the European Court of Human Rights, I think it will contribute to the credibility of the human rights advocacy efforts which the LGBT organizations try to implement, and it will demonstrate the international community of states that human rights of LGBT persons, it is something enshrined in the human rights treaties based on the Universal Declaration of Human Rights dating back to the establishment of the United Nations as the mechanism not only for supporting cooperation of the states, but also for supporting human rights as a path for cooperation between states. And also, I think that by bringing more and more cases, and which demonstrate that they will demonstrate that the recommendations of the UN human rights bodies, they addressed to the states and the concluding observations, they are pertinent, they are important because the individual cases demonstrate that those recommendations, they are not followed, they are not implemented by the states, and that's why the work of the committees is something related to real life stories of the applicants, and not only to the cooperation between states. All right, let me stop here, and I will give back the floor to the organizers. Thank you.
Thank you very much. Thank you, Dmitry, and specifically thank you for addressing the issue of legal status of decisions, because we had one question about what is the legal nature, what is the relevance of the decisions, and one of the participants already was interested in this. So I think that this question was perfectly answered here. Now we have ARPI. So Dmitry already mentioned how the European Court of Human Rights could, jurisprudence on LGBT cases could be compared to jurisprudence of treaty bodies, and ARPI, being an expert on European litigation, could also tell us more about it.
Thank you, Ksenia, and thank you for the invitation to join this webinar. It's really a pleasure to be here and to share our experience, which hopefully will contribute to bringing more cases, more submissions also to UN treaty bodies. I have a very short presentation. I'll try to share the screen, if that works. As ILGA-Europe, we work we've been working mainly at the European level, because up until recently we were covering mainly European states, Council of Europe member states. So our efforts were focused mainly on the European courts in terms of standard setting, which is one of the areas of our strategic litigation work. Of course, other areas including capacity building and mentoring and providing resources are also important, but we've seen that standard setting is important to bring kind of more efforts to the protection of LGBTI rights across Europe. And now, since that we have Central Asia joining ILGA-Europe's kind of mandates, that there is a need to, in addition to the need to, as Dmitry said, as an alternative to the European Court, for those that have access to UN treaty bodies, but also that it's the only access for Central Asian countries. So we'll be devoting more efforts to submissions before the UN treaty bodies. So very briefly, I'll speak about, as Ksenia mentioned at the beginning, about what is a third-party intervention and our experience with the interventions. And when we speak here about third-party interventions, we speak about amicus curiae submissions that are submitted to assist the courts, like friends of the courts, to assist it with adjudication. So since we've been more, our experience comes more from European courts perspective and litigation there. I actually just looked for this webinar, to remind myself, when was the first submission that was done by ILGA-Europe? And it's actually 20 years ago, which is quite some time already. And the first case that we had intervened was the French case concerning adoption by a single person. In that particular case, in Fred versus France, it was a gay man And while at the time, actually, the decision, the judgment from the European Court wasn't positive, but there was a very narrow margin that it could actually become a positive judgment. It served as a beginning for continuing to feed more information to the court. And later, as Dmitry mentioned, we've seen very progressive judgments from the European Court. One thing to mention that while at the beginning, 20 years ago, it was 1 or 2 cases per year that we would intervene. One of the reasons was that it was done externally by Rob Wintermute mainly, who is an academic supporting ILGA-Europe. But also there weren't that many cases before the European Court to be considered. And since then, more cases come to the European Court on a variety of rights related to of LGBTI people, and with more kind of capacity for ILGA-Europe and infrastructure, with having allies, partners who also intervene with or support each other. We've done about 10 submissions per year, which is incredible, and it's really great to see cases coming to the court and developing the standards. As I said, we've intervened in a number of cases, and they've covered legal gender recognition, freedom of assembly, freedom of association, hate crime, hate speech. Lately, we intervened in 2 cases concerning mass arrests and detentions, which unfortunately is happening in a number of countries. Recognition of same-sex couples, that there's been a positive judgment, but there is more now, and actually we're hoping that with our submission in a pending Romanian case, we can actually bring more clarity and support the courts to bring more clarity on this issue and have a stronger judgment than it issued a few years ago concerning Italy. For asylum, actually, you mentioned that there weren't cases, positive cases from UN treaty bodies on asylum rights, non-refoulement rights, and this is an area that is still not really covered by the European Court. We continue bringing cases when there is an opportunity, because LGBTI people are really affected by this and lack of standards that could really address the issue. So then this is all available on our website, which I will also share later for those interested to see our interventions. But also to, in terms of seeing cases coming to courts, it also shows about the rights and the need to address those rights, rather than having them, I'd say, invisible before. At ILGA-Europe, we intervene in strategic cases, and those are the cases, as Ksenia mentioned, and it's clearly and very nicely put in the policy paper, but those are the ones that have a broader impact on rights within a country or within a region. So as much as possible within our capacity, we try to intervene in strategic cases. And while the cases are pending, our submissions are public, and they've proven to be useful not only as an education kind of tool for courts, but generally as a resource our members, activists, lawyers are also using. So third-party interventions can be used in many ways, even outside the courts. So to speak about third-party intervention, how we work and what are the premises, the procedures, I guess would be useful also to address before the European courts. There are 2 courts in Europe, but as I mentioned, we mainly make submissions to the European Court of Human Rights. because there is a clear procedure and because it's a human rights court that can address and provide protection to LGBTI people. And as a procedure, the third-party interventions were more codified kind of with Protocol 11 coming into force in 1998. Before that, it was kind of more of an ad hoc procedure. But with Protocol 11 coming into force, there is an article which provides, and you can see it on the screens, that the president of the court may invite either high contracting parties or any person concerned who is not the applicant. And this provides an opportunity for civil societies, NGOs like us, to make submissions and to provide the court with comparative examples, international comparative law, but also broader kind of situational information. We, most of the time, wherever possible, we invite one of our members to join to also provide the context where particular cases are taking place, because that's very important for the consideration. I also thought it would be useful to provide a bit of information on how the procedure works. For the European courts, there is a very specific timeline when NGOs or, as mentioned in Article 36, persons can make submissions. So within 12 weeks after a case has been communicated, interested parties have to ask the court to allow for intervention. And usually when we do this, we try to do it in coalition with our partners, because there is a breadth of experience and expertise that can come with it, but also to show the importance of the case and of the issue to the court. And then we usually get a deadline by the court by which we have to make our submission, and a page limit, which is usually 10 pages. In terms of European Court of Justice, which is based in Luxembourg, and it actually addresses the EU law issues. And while it does affect LGBTI people, it's more confined to EU law. It must be with freedom of movement, for example. It cannot be per se on family rights. So it is very different to the European Court. And also, the parties that have been involved in domestic level, it's only those ones that can be considered as parties and third parties before the ECJ. And then to move to UN treaty bodies, we don't have much experience, but we are considering this this avenue, as I said, for our members, the cases that would be coming from Central Asia, but also because courts look at each other, courts learn from each other, and for the international comparative law perspective, there is a very huge importance to have supportive decisions, developments from different treaty bodies, different tribunals or courts coming into. And likewise, we would refer to Inter-American Court of Human Rights, for example. So with UN treaty bodies, when we do interventions, it would be bringing in the European perspective where the European Court has a developed jurisprudence and a clear standard that would help UN treaty bodies. But also where there are gaps at the European Court, a decision coming from UN treaty bodies would be very helpful the other way around. One of the examples, actually, just to mention briefly, I know time is very short, but to mention briefly, for example, Fedotova versus Russia case, which the decision by the Human Rights Committee was delivered in 2012. and concerned the propaganda law, application of the propaganda law and administrative fines as a result of it. The Human Rights Committee was very good in stating clearly that was in violation of freedom of expression of the applicant, and it was discriminatory. And then later came a judgment from the European Court, the Bayev and others judgment, which Dmitry has been litigated and represented the applicant, which came later, and it was already, Russia had the obligations actually as established by Human Rights Committee, but also it was much stronger judgment from the European Court, and it felt that the cross-fertilization, learning from each other, looking at each other was also very helpful. In terms of third-party interventions, now going back to treaty bodies. The treaty bodies have been kind of providing procedures and codifying this more lately. But it's also very useful because that provides an avenue for NGOs to know what exactly needs to be submitted, how to prepare for it, to take all into account. And I've just mentioned the procedures being more explicitly clarified by various treaty bodies. The first one, Committee on Economic, Social, Cultural Rights from 2016, and then followed by CEDAW in 2018, later Human Rights Committee and the CRC earlier this year. They also, like the European Court, set certain limits to provide guidance to the interveners. And it's important to strengthen decisions from treaty bodies because some of the, as already we discussed, treaty bodies provide some of them specialized views. So the Committee on the Rights of the Child will be quite specific and addressing the specificities of children's rights, which would be very useful for example, European Court consideration. And then similarly, the CEDAW committee addressing women's rights is very important to bring a learning experience to other courts. So I guess the time is short. I will stop here and I will wait for any further questions. Thank you.
Thank you so much. Thank you so much, Arpi, and thank you for sharing amazing, so important experience of ILGA-Europe in bringing cases and supporting cases, not only before treaty bodies, but also the European Court of Human Rights. So we have also Rosanna, who can share her experience of working and bringing an actual case to a CEDAW committee. So Rosanna, could you please tell us more about what's the case, why you decided to go there, and what's your hopes about your case?
Great, thank you, Ksenia. Thank you so much for ILGA for having me on this webinar. I have to say I'm a webinar virgin. I've never done this before, so I probably pressed some wrong button and you will all disappear in any second now. But just wanted to say thank you and good evening to everybody. Late evening here in Sri Lanka. You know, the question, and this is the question that everybody asks, and I think, Ksenia, you've got also a question from somebody covering or asking why, you know, I brought this case. So I think one needs to actually think or see the background of the legality of LGBTIQ in Sri Lanka. First and foremost, we do have the Penal Code 365 and 365A that criminalizes adult same-sex sexual relationships. In 1995, the wording was amended to drop the word male, and in doing so, it also included women as, you know, behaving criminally for loving somebody of their same sex. We also have a very interesting constitution, which in 1978 put in a clause, Article 16, saying that any law that was already established before the constitutional changes in 1978 could not be challenged, cannot be challenged in a court of law. So we really don't have the quote unquote luxury of taking this case to the Supreme Court and saying, hey, we are being discriminated because of the people we love. And it is unconstitutional as well as a human rights violation. So this is the reason why I took my case to CEDAW. The other question is, why CEDAW instead of the HRC, for example, which is also part of the question that came in here. But Ksenia has already said, mentioned Toonan versus Australia. So there is a precedent already set in HRC. It also takes a lot longer for HRC to actually come up with any decision, probably around 10 years as compared to CEDAW, which might take between 3 to 4 years to come up with a decision. And I don't know about any of you, but I don't have 10 years. It's too long. It's too long to wait. So I figured, the best thing to do is to go through CEDAW, because it is such a violation of the CEDAW covenant to have same-sex relationships between two women criminalized based on a archaic British law that was put in place in 1883 in Sri Lanka, criminalizing consenting same-sex adult male relationships. So in 1995, now it includes women as well. So in a nutshell, that was the reason why I brought this case to CEDAW, because we did not have any option other than to do that. Now, one of the things that is required, which is mentioned earlier in an earlier presentation, of course, was the fact that we had to exhaust all remedies in country. And since we cannot take this case to the courts, it has basically exhausted all remedies. There's no remedy, in fact, in Sri Lanka for us to apply to. The other thing is that since Sri Lanka has signed on to the optional protocols, it meant that we could take the case to the UN. Otherwise, we would have been left with no place to turn to and just, lobbying constantly within our country circle to try and get this laws overturned, which in 20 years of my activism in Sri Lanka, we haven't even seen a glimmer of hope on this issue. So I felt compelled to bring the case to CEDAW because I think it's so important that litigation does take place at whatever level we can use. Because as activists, I think that it's very difficult to look at things from a law lens, for example, or an academic lens. Definitely, the law lens might say a different thing, the academic lens might say a different thing, but us activists are saying, now, we need this done now, yeah, and it might not happen for another 3 years, 5 years, 10 years. Of course, the Sri Lankan government has rejected my claim, saying, that I should exhaust all remedies because they seem to think that I have a remedy, whereas we seem to think that we don't have any remedies, which has been also verified by, experts' opinions from Sri Lanka as well. The government of Sri Lanka has been notified. The government of Sri Lanka has replied twice. Both times rejecting my claim. So now it's up to the CEDAW committee to also field the thing that we sent for the government's claim, saying that our version of why we are claiming that this is an unfair law and that it needs to be changed. So it's now up to the CEDAW committee to make a decision as to whether the government should get rid of these, repeal the law. I'm hoping that when they're asked to repeal this law, it would not only be to repeal the fact that women are criminalized under this law, but to repeal the law in general for all sexual orientations and gender identities and expressions. I'm keeping my fingers crossed. It's the first case of its kind, I think, challenging criminalization at CEDAW. I think it's also the first case from Sri Lanka, if I'm not mistaken. So it's a heavy burden, but yeah, it's something that had to be done. And unfortunately, Sri Lanka has seen quite a bit of turmoil since I filed the case in August of 2018. The government of Sri Lanka was notified on in October 2018, and then soon after there was a constitutional coup, and then after that, in April, we had the Easter Sunday bombings. We went into lockdown for a few days. There's been a lot of turmoil. And in November, we had a new president being sworn in. So now we've got the COVID virus. Our general elections have been postponed from April to June. We don't know what's going to happen. I think our parliament has been dissolved. So we are in a state of flux, and nothing is helping at the moment. So we're just keeping our fingers crossed. And I'm going to end there because I think, as Ksenia says, also we have very little time, and we would also love to hear from all the participants who are watching this webinar. So I'm going to leave it at that, and over to you, Ksenia. Thanks very much.
Thank you so much, Rosanna. And of course, we will be following the development of your case on the CEDAW level. And of course, finger crossed, and we will all support you in this fight. So I know that we are running out of time, but almost, not yet. Yeah, we still have some time. So we have also Tess, who can share with us experience of also working with third-party interventions, which means that through third-party interventions, you can participate in this litigation process, even when it's not actually your case, but still you can provide your knowledge and information. And just to remind that we have a Q&A section. If you have any questions, please put them there. So Tess, thanks. The floor is yours.
Thanks so much, Ksenia, and thank you again for the invitation to share some experiences. So what I'm going to do is I'm going to build on RP's intervention and briefly speak about the importance of third-party interventions, and then a little bit on some cases that we have intervened on, both as a third party and on behalf of an initial applicant. So thank you for the slides, also for controlling them for me. So third-party interventions have become more common and accepted in various courts over the years, and also become more valued by courts. And they're important for a number of reasons. Primarily, we see third parties as a crucial means to support human rights defenders who are fighting on the ground. So in a way in which international organizations like ourselves can provide legal support to these interventions. They enable courts to hear arguments that extend beyond, but are relative to, the concerns of a particular case. For example, where there are broader implications or policy considerations, and groups beyond the particular party to a case have an interest. So they encourage the court to scrutinize the case in its context and to strengthen a court's decision so it has a wider application. So for example, we see these as crucial to support defenders fighting on the ground, because we would intervene in a case on attacks against a single LGBTI human rights defender to seek that that decision of the court can be relied on by an entire human rights defender community in that country working for the protection of LGBTI rights, and can be essentially applied as widely as possible, and ideally to prevent similar violations in the future. So to assist with this, ideally a third-party intervention should seek a structural change. It should seek remedies that are aimed at preventing similar violations from occurring in the future, such as changes to policy, to laws, and to practice. As RP mentioned, they can also assist to provide comparative studies. So assisting one court to look at work of other bodies and courts in the way they've applied similar rights. For example, the International Covenant on Civil and Political Rights, the American Convention, the European Convention, and national laws encompass the right to be free from discrimination. And the way that one body applies that can be useful to another body in applying that right. They can also help to strengthen documents as binding international law. So if we think about the Yogyakarta principles, and for those of you not familiar with those principles, they're a set of principles developed by experts that apply existing human rights law to issues of sexual orientation and gender identity. And references to those principles in a decision of a court or a human rights body can assist to strengthen those principles as constituting or as being relevant to international human rights law. They're also important beyond the immediate decision in a case. So next slide, please. They can build solidarity and support among civil society organisations and among human rights defender community. For example, there are coalitions that exist that are kind of more formal coalitions that provide a mechanism to identify opportunities for collaboration. So where NGOs can advise of cases they're submitting to others within that coalition and invite others to submit a third-party intervention in support of that case. Alternatively, there are more kind of informal alliances. For example, ISHR and ILGA-Europe will submit a joint third-party intervention on a case in a national court in Kazakhstan. And the idea here is to bring together our experiences at the regional and international level to highlight this violation that's happening at the national level. It also provides a way for us as international organisations to be led by defenders on the ground, a way that you can tell us how we can support you in your strategic litigation at the international, regional and national levels. And finally, I just want to mention the concept of multiple points of leverage. Campaigns that are more likely to succeed are those that don't put all their eggs in one basket. So including strategic litigation or a third-party intervention as one element of a campaign with multiple points of leverage. For example, along with a media strategy and media engagement, or along with advocating at other UN mechanisms, can also help to strengthen that overall campaign. So for ISHR, we conduct strategic litigation at international, regional and national levels. As I said, we work on third-party interventions, and the reason why I've just explained. We also submit initial cases to various treaty bodies and other bodies. So we do this to ensure that defenders have the freedom to protect and promote human rights, that perpetrators are held accountable, and that victims are provided with adequate remedies. I want to speak to a couple of cases here to demonstrate some of the ways we have used both third-party interventions and also strategic litigation in our advocacy to protect human rights defenders, including LGBTI defenders. Next slide. So we have intervened in a case involving attacks against Sasha Krikarik, and I apologise if I said that terribly with my Australian accent. She's an advocate working for the protection of LGBTI rights in Russia. And Sasha and her colleagues were physically and verbally attacked in both public and private settings, and the Russian authorities failed to either investigate or act on these attacks. So the reason I wanted to talk about this case is for a few reasons. One was to kind of highlight the intention behind our third-party intervention in this case. So in this case, the applicant argued that Russia had violated the International Covenant on Civil and Political Rights. And our third-party intervention argued that the rights under that covenant should be interpreted broadly, and that articles and principles in the Yogyakarta Principles and the UN Declaration on Human Rights Defenders should inform those rights. So the Yogyakarta Principles and the Declaration have been developed since the ICCPR, and both set out more detailed obligations of states regarding the ICCPR, relevant specifically to LGBTI individuals and human rights defenders. So we called on the committee to decide that Russia violated the International Covenant on Civil and Political Rights, the UN Declaration on Defenders, and the Yogyakarta Principles. So we see that such a decision would contribute to enhanced protections of LGBTI defenders in Russia. It would provide clear calls for civil society to echo in their advocacy, and it would also strengthen the UN Declaration and the Yogyakarta Principles in terms of the extent to which they can be relied upon and guide the interpretation of binding international law. The second reason I wanted to refer to this case is because it was initially filed with CEDAW, that Russia had violated rights under the Convention on the Elimination of Discrimination Against Women. However, the case wasn't accepted when it was initially filed with CEDAW, and it wasn't registered with CEDAW. So in response, the applicant then decided to file the case with the Human Rights Committee. I think this is important to highlight for two reasons. One is that it indicates that there is advocacy work to be done with certain treaty bodies seeking to widen the lens on cases that it will accept under its complaints mechanism. And as other panelists have identified, there's more and more cases being filed, and the more cases that we can file, as well as external advocacy on these mechanisms, we can help to strengthen the mechanisms. Secondly, I think it highlights that it's important to consider all forums for a potential case, so those both regional and international. And in this case, initially it was thought that CEDAW would be the best forum, given there's less of a backlog as compared to the Human Rights Committee. But given that it wasn't registered, the case has now been filed with the Human Rights Committee, and now over 3 years later, we still haven't received a decision. I want to, given the time, I'm just going to end by just mentioning 2 other cases very, very briefly. And they are talking about essentially the various objectives that you can have when submitting a case. So we submitted a case to the Human Rights Committee on behalf of commissioners in the National Human Rights Institution. This was specifically on restrictions placed on that National Human Rights Institution after it submitted a report to the UPR of the Maldives. Essentially, the government sought to silence the National Human Rights Institution after it communicated with the UN. So the objective in this case was to call on the government to lift those restrictions and amend laws which gave the government the power to place those restrictions. And in this case, the committee did make recommendations in that regard, and in response, the government proposed amended legislation to address those violations, which will address these issues going forward. So while this is a really positive development, in our response, we've also called more on the Maldives to provide an effective remedy for past violations. And another case in comparison we filed before the Committee Against Torture, it's similarly about 4 human rights lawyers in Burundi who were disbarred following communicating with the Committee Against Torture. But given the administration in Burundi at the moment, we don't expect that the government of Burundi will address the cases adequately. However, we submitted this case to build greater attention and awareness and a record on impunity and lack of accountability. We saw that this case was another moment to spotlight and provide protective publicity. So I'm going to end now because I know we're really running out of time, but I just wanted to acknowledge, this is a relatively new area for ISHR, and for that reason, there's very few cases that are referred to that have actually been decided. However, they're essential as a means of working to protect human rights defenders, and specifically LGBTI defenders, and one which we should be used as part of a wider campaign. So I'd like to just close by saying, if you are working on any of these cases and you see that or consider that there may be opportunities for collaboration and solidarity, then please do reach
out. Thank you very much, Tess, and thank you for all the support provided to LGBTI movement by ISHR, and thank you for collaborating on these cases together with us and local defenders. So we are running out of time, but maybe if anyone has any questions, you can send them to Q&A box, and maybe we will have just 5 minutes more to answer it. There is a case, the case maybe for Dmitry, Arpi, Tess, but also Rosanna. If you could share your experience on choosing the right case to take it to relevant body or court. What do you consider relevant in order to decide which case to focus on?
Should I answer that very quickly? I think, for me, there was no other case really to bring about, because we really had our hands tied, or we still have our hands tied here in Sri Lanka. Unfortunately, because a lot of LGBTIQ community members in our country are afraid to be out and afraid to actually challenge anything in a court of law, or even international courts, there was no litigation happening on behalf of the LGBT community here in Sri Lanka or internationally. So I felt that I had to do something, because my rights are being impinged on by, labeling me a criminal for loving another woman. So, and everybody says, it's not the right time. It's not, and no time is the right time. the right time is when you feel you need to do it. And the right case is when you feel here in your heart that you need to do it. I don't know what the lawyers will say. I'm talking specifically in the case of an activist and as an LGBT person.
Briefly intervene at this point. I think there is absolutely no universal recipe, and in every country there is a unique situation. Not so many human rights organizations, I think, have a luxury of having like a broad variety of cases to choose from, actually, for submitting to the international bodies, because bearing in mind the requirement of exhaustion domestic remedies, it is extremely hard in many countries or on many issues to exhaust domestic remedies, so basically to bring the case through the domestic judicial system. As a human rights attorney with years of experience, I think, first of all, you cannot make up an artificial case. I think you should always bear in mind that to have a successful case, and by saying successful, I mean not necessarily legally successful, but the case which can bring changes, which can be viewed by the community as something important, as something relevant. So to have a successful case, you have to have the case should come, so to say, naturally from the activists, from a person whose personal experience, whose rights have been violated. So you cannot just, as an academic or as a lawyer, just pick up an issue and say, well, I want to litigate this, so let's go to certain international or domestic forum, because unless you have a story behind the case which makes this case kind of trustworthy, you cannot advance the case. Other considerations which you might need to take into account, of course, is the state of jurisprudence and the of certain forum. As has been said throughout this webinar, in particular, the European Court of Human Rights might be more acceptable to some novel issues, but at the same time, given the very important restrictions on bringing cases to the European Court of Human Rights and other human rights bodies, when you have to have an individual victim, certain issues, like, for instance, general hate speech, which is not addressed towards particular individuals with particular victims, might be more successful for litigating under the UN human rights committees, because they might, or other procedures, not necessarily individual complaints, because they might be more receptive of such cases raising not necessarily individual rights, but human rights kind of violations in general. Or maybe you should even consider bringing the issue via the mechanism of the Human Rights Council, so by reaching out to certain states which could raise the issue on behalf of LGBT communities.
I can jump in also just to really support that from the international perspective. Everything that's been said by both Rosanna and Dimitri, I echo everything there, and really thinking about what is your intention with a case is always going to be different. Is it about highlighting a violation? Is it about changing a policy or law? Is it about bringing something through the international system with the hope that it will then go to the national system to change the law at the national system? So there's never kind of a one answer that would bring you to bringing a case or submitting a third party intervention with an international, regional, national court. But there can be many reasons why you do it, and then considerations about which forum to file that case in, what are the specific calls we need to ask, do we want a third party intervention? And what are the other elements we want to bring into that campaign? Is there a media campaign? Sorry, is there a media strategy? Do we have other kind of forum that we can bring into that discussion? So it's kind of bringing in all those different conversations about how best to take that forward.
Thank you.
I just mentioned very briefly, I mentioned, I know we're running out of time, but I mentioned previously that we do strategic litigation. And of course, just to build up on what Dimitri and Tess have said, it depends on the cases. Human story is very important, but also how the case is built and how it's supported is also very important. And sometimes, of course, there are activists who bring the cases. They're more aware of what to do and how to do. Sometimes we come across a case that was brought by someone who really felt that they had enough and they wanted to take the case. And it's not an activist that we know. It's just we don't know this person from our contacts, membership, community contacts, etc. But then it's very possible to support this case as tested through campaign within the community or through a third-party intervention to bring in to support the arguments, because the arguments may not be built as a strategic case, but as someone who just felt they wanted to take a case.
Thanks, Arpi. We also received several questions about resources. So people mentioned that litigation could be very expensive, and I think it's really important thing to discuss. So people just ask where to get money, are there any avenues to provide resources for strategic litigation, and also how to ensure specifically safety of, I guess, applicants. So maybe anyone wants to share their experience or ideas or specific advice on this? Resources and safety.
Well, I can speak to my case. I know that I don't have the resources myself to do this, but Human Dignity Trust in the UK helped me file the case. And this was a huge bonus for us because, you know, not only did we not have the technical know-how, but they helped with every single aspect. They held my hand right throughout, and they're still holding my hand, by the way. So all expenses are borne with them. Everything was done pro bono by all the lawyers. So, you know, there and ILGA, I'm sure, as well as ILGA-Europe, other organizations in the United States and in the UK, I'm sure there are so many pro bono organizations that can step in and help internationally. And I'm also pretty sure that there are several pro bono organizations like iPro Bono, for example, working in country that can help you with litigations without you having to spend money that you don't have or whatever. So, yeah.
One brief comment maybe on this as well, if I may. Of course, for certain countries and for certain contexts, the issue of where to find the right lawyer or how to litigate the case, that might not be the most important issue, because even if you have resources, even if you have access to pro bono legal assistance, but still the safety considerations might be much more important, and it's the ultimate decision of the person, him or herself, of the activist, to pursue the case, knowing and understanding all the ramifications which may follow when you declare the case officially. So in this case, actually having the international attention to the case right from the very beginning, not after the domestic remedies have been exhausted, might be actually also a solution for protecting the interested person. And the role of the lawyers, of course, is to advise the person how to use, how to make use of these opportunities to protect himself during the proceedings.
And to echo there, I think, so pro bono law firms are super useful. There's also some universities that have law clinics and have law students there willing to assist with certain cases and research. Thinking about regional and international organizations like ourselves that do work in this regard, that either have legal capacity internally or also have connections with pro bono law firms or other ways for those resources. to be developed. And also thinking about safety, I think ensuring that the conversations that take place in relation to a case and the progress and the direction for the case need to be considered in line and in consultation with the defender or the person whose rights are violated. And I think safety needs to be one of those primary conversations that happen at the very start. So when determining the strategy and any other outlining elements in the campaign in terms of confidentiality, being public in terms of the media, things like that, ensuring there's real consultation happening there and that those decisions are led by the defender or the person whose rights have been violated.
Mm-hmm. I maybe will also add on this point, because first you can find some information on useful contacts, including pro bono lawyers in our policy paper. But of course, there are a lot of pro bono firms and organizations who are doing it specifically PILNet. Also, when it comes to money and at the same time protection, there are several urgent action funds which could provide actually money for physical safety, for lawyers, sometimes for, but not as much for strategic litigation. But there is an opportunity, for example, protectdefenders.eu, and especially when it comes to LGBTI human rights defenders, you can get support in different forms, including financial form, quite quickly. If there is, for example, an attack on LGBTI persons or defenders, or when you need to what's the name of this? When you need to help a person to leave the place, for example, when it's not safe for them. Relocation support also. Also, there is a question on, also there are some funders, like general institutional funders, who sometimes provide money for advocacy, including for strategic litigation. And there are funders who provide institutional support in the sense that you don't have to have specific purposes or specific projects for this type of activities. There is a question, how do we follow Rosanna's complaint? Rosanna, maybe you can have some ideas on how people can follow your the development of your case.
Actually, I don't even know how to follow my own case. I have actually asked for anonymity on my case now, mainly because of the change in government, and it is not a very friendly government that is now in place. So I think it will be difficult to follow it. So I actually have to. I really don't know the answer to that question. I think it's since I've made it anonymous, I don't think that people can easily follow the case now.
Mm-hmm. Thank you, Rosanna. But also, because we also work with CEDAW, and when we will have some information which could be publicly available, we can also share it with the wider audience. And of course, when
there's one more question. I'm sorry, there's one more question in the chat, just in case, because it's not in the Q&A section. So the question is, panelists have mentioned the benefits of cross-fertilization, particularly RP. Applicants leverage the result of litigation before one court in litigating before others. To what extent is it possible to purposefully coordinate litigation across different rule systems?
Unfortunately, purposefully, I don't think it's possible, because there is no guidance as to when courts or committees would look into cases, deliver judgments, and that there are many variables coming to come into place to make a judgment to be delivered. For example, at the European Court, there are cases that have been pending for 6, 7, 8, up to 10 years. But sometimes on a similar issue from another country, for example, on civil partnerships, on recognition of same-sex couples, there's been a group of cases submitted by Romania in autumn last year. They've been communicated, and already now is the consideration a stage, and we've asked to intervene. But this is quite a quick turnover. So I'm afraid it's not really possible to give an answer, but UN treaty bodies have been so far quicker to consider cases and deliver decisions. So that also might be something to take into consideration, but depending on an issue, depending on the approach of the committees, as has been mentioned before, those are all important considerations to take into account, whether to take a case to one forum or another.
I briefly add here. There's also one we haven't discussed so much in this presentation, but the Inter-American Commission and Court on Human Rights. So I just wanted to very, very briefly bring that in here, especially in response to this question, because I think that's also really another important fora, and a case we're working on at the moment is a third-party intervention with the Inter-American Court on Human Rights in relation to the killing of Vicky Hernandez, a trans human rights defender in Honduras. And, you know, in Honduras, Vicky is one of many trans defenders that have been killed in recent years. And so I think this kind of is an example which shows a reason why to intervene on this case is because this is a systemic problem that's taking place in Honduras. So many defenders are being killed, especially trans defenders, and Vicky's case is one of those cases, but also a good example of that cross-fertilization in terms of our third-party intervention is focused on bringing in jurisprudence from the International Covenant on Civil and Political Rights, the UN Declaration on Human Rights Defenders, the Yogyakarta Principles, and the Yogyakarta Principles plus 10. So how can we bring in that discussion into this regional analysis and help to bolster both? And I think while, as Arpi says, it's really complicated to do kind of a timed, broad-based kind of application in various different forums at once, in doing this, so even in this kind of piecemeal way, that really does help to strengthen that cross-fertilization and support that and strengthen that jurisprudence.
Arpi?
Yes, very briefly on this point, actually, on the Inter-American Court of Human Rights. So I mentioned we've been making submissions on mass detentions and torture, the cases in Chechnya, for example, and it followed in Azerbaijan as well. And we have intervened in both cases before the European Court of Human Rights. And while we were working on those submissions, actually another case of a trans person who was tortured in detention, but previously it was based on sexual orientation. So it was very kind of useful to the considerations that we put in forward for the European Court. So then we actually intervened with all the materials on positive obligation and of authorities, non-discrimination, and how torture can be, the discriminatory torture against LGBTI persons. So we actually made a submission to the Inter-American Court, which issued a very, very strong judgment. And now we're waiting for this judgment to hopefully be taken into account by the European Court. So it wasn't planned at all, but it just, we happened to know because we made a submission with redress and they mentioned the other case, and it's not the usual practice, but we intervened. So it's just, I think, yeah, taking the opportunity when it comes as well.
Thank you so much, Arpi. Thank you to all of our brilliant experts for sharing your experience and wisdom and struggles, and I hope that this webinar was useful for many of you. You can contact us, and if you have any cases, any specific cases in mind which you want to bring to treaty bodies, you can contact us, and you can also check our resources to know more about new cases and about development of cases such as Rosanna's case or cases which Dmitry's mentioned. Yeah, I think thank you so much for staying here, especially for additional 25 minutes. I would ask you once again, when you will leave the webinar, there will be a survey. If you can just spend 2-3 minutes to fill it in, it would really help us. After the webinar, we will have also a follow-up email with a video and some materials from this presentation so that you can use it after that. And also we will have some other webinars and roundtables in the future on advocacy and on different topics relevant for LGBTI community. So thank you everyone, and have a nice evening, morning, day, whatever you have in your parts of the case. Thank you so much in the world. Thanks.
Thanks so much. Bye-bye, everybody.
Bye.